A major January 6th victory was reversed. This came out of the Court of Appeals from the D.C. Circuit. I want to go through this opinion because this has the ability to go up to the Supreme Court, potentially change a whole slew of January 6th prosecutions or not. It depends on how this one rule, one statute is interpreted. And I want to take a quick look at the statute itself because we've covered a lot of the January 6th cases here. And a big bucket of the criminal charges have fallen into this statute. And if you go over here, you can look up 18 U.S. Code. It's called tampering with a witness, victim, or an informant, section 1512. Now, as we go through this appeal, what we're going to see is that it's focused on subsection C. And in particular, it's about an assault. So there it is. Here, there is a big question. There's a category of January 6 crimes where they're saying that there was an obstruction that impedes an official proceeding. C2 is the section we're going to see a bunch of. This was just reversed. They were saying, the government was saying that this phrase corruptly is a very low standard, that it just kind of means whatever. And it applies to the J6ers. And if we zoom out on this just a little bit, remember, in a criminal case, there's two parts, sort of like 1 + 1 = 2. We have a mens rea and an actus reus. In order to be guilty of many crimes, you have to have a guilty mind and a guilty act, some mental state and some act. In this statute, here what you see is obstructs, okay, that's an act, influences or impedes any official proceeding. Right? So you can do that, that's an act. We're not asking about the act. That's pretty much a foregone conclusion. In many cases, there was some obstruction that was going on. There were people standing in the way. The question was, why were they doing it? What was their mental state? Was it done corruptly? And what does corruptly mean? The J6 defendants were saying, I don't think corruptly means what the government says it means. And the government says, well, if you do anything wrong, basically, that fits within the statute. And the defense says, no, it should be much higher than that. And that the J6ers didn't do it corruptly. And a lower level court found and agreed with the defense on this. They said, holy moly. Yeah, if we give this word corruptly a broad reading, then anything you do can fall into that category. And so we're going to make it very narrow. And the D.C. Circuit Court of Appeals just reversed that. So a potential bucket of a bunch of January 6 crimes that could have been theoretically dismissed or not charged are not going anywhere yet. Let's dive into the opinion. It is a bit of a long one, and so we'll go through it as fully as we can out of the United States Court of Appeals for the District of Columbia. Major case. An appeal from the D.C. lower level court, and they argued the case. Now, here is the opinion. You know that there was the majority opinion, and then we have a dissent. Here is what the judges write. They tell us. This is the majority opinion. As Congress convened on January 6 to certify the results of the election, thousands of supporters of the losing candidate, Trump, converged on the United States Capitol to disrupt the proceedings. The Trump supporters, they say, and forget about that you can add in at least plus 40 feds, confidential human sources. So Trump supporters and 40 CHSs, they forgot about that. We learned about that in the Proud Boys trial. Swarmed the building, overwhelming law enforcement who attempted to stop them. The chaos wrought by the mob forced Congress to stop certification and flee for the day. Congress was not able to resume its work for 6 hours. Wow. The question raised in this case, this is the key issue, is whether individuals who allegedly assaulted law enforcement officers while participating in the riot can be charged under that statute, the one that we just read, 1512C2. Could they be charged with corruptly obstructing? Now, I know it's technical, but we're going to break this down. The district court held the statute. The lower level court said that it does not apply to assault committed in this type of context, which was great. That means that everybody who is charged with this is not liable because it can't apply, because that type of conduct was not done corruptly according to the judge. Of course, and this was a rare victory. It was on appeal. The DC Circuit Court of Appeals comes back out and says, we disagree, and we reverse. They write, here's what happened. They say these defendants were charged in separate cases for participating in J6. We draw from their complaints. They say that Fisher was a part of the mob, and he charged and told others to hold the line. And they go through some of the things that he said. If Trump don't get in, we better get to war, and all of the things. They recount all of that. Lang, they talk about him, was another member of the mob. Miller also apparently brought a grappling hook. He said that he thought a civil war could start. Oh my gosh. Other people were posting on Twitter and Facebook, and they were saying bad things on there. And so the government charged all of them with a bunch of charges. You see all these charges here, misdemeanor, disorderly conduct. Wow, disorderly conduct. Wow, great. They also had another disorderly conduct and disruptive conduct. These are all the most embarrassing charges ever, right? These are, as I said, these happen every time you go out to an Old Town bar on 6th Street, wherever it is, you're at Mill Avenue, Scottsdale, whatever it is. You have disorderly conduct dozens of times. This just happens to be in the Capitol building, which turns it from just a very boring, very minor crime with very minimal elements, not even a big deal. I mean, in terms of complexity. Legal complexity. They're not complex cases. Are you where you're supposed? Are you here? Yeah. Are you supposed to be here? No. Okay, that's it. We have your ID. Okay, that's pretty much it. Is trespass, disorderly conduct very much the same thing. So trespass crimes, disorderly conduct crimes, restricted building crimes, all of these crimes, right? It's like whatever. Now, the felony assault count is the bigger ones. It's the ones that are more serious. It alleges that each of these defendants did forcibly assault, resist, oppose, impede law enforcement in the execution of their duties in order to commit another felony. And they go through the indictments and they explain what those are. They say the government also charged each defendant with other official obstruction charges, and they put that in the indictment there. Here's another indictment. They say we read the statute, whoever corruptly obstructs, right? Corruptly obstructs. C2 is the statute we're trying to unpack here. So the district court went through all of these motions and concluded that this section is ambiguous. They said, we don't really know what corruptly means. They say that C1 concerns a record, a document, or other things. The district court focused on the meaning of the word otherwise that connects the two provisions. Here, this word right here, or otherwise obstructs. So can they charge this person? In any criminal case, the way we often talk about this are like there are check boxes that the government has to hit. And so we draw these check boxes out and they say, okay, well, we've got to have each one of these boxes checked off before we can convict somebody of a crime. In a DUI example, you're in actual physical control. You're driving a car. You have a blood alcohol limit over a certain amount and you're within the state of Arizona. Okay, great. There you go. Arizona DUI. You've got 3 elements there. Boom, you got it, right? Simple example. They're trying to do the same thing here. And the judge is reading it and he's saying, okay, well, it says here, whoever corruptly destroys an object's integrity or otherwise obstructs or influences, it almost means that follows the first paragraph. Let's see what they say. They say that the lower level court focused on otherwise, relying on its understanding from the Supreme Court. That led the district court to hold that the subsection C2 requires that the defendant have taken some action with respect to the document in order to corruptly impede the official proceeding. And because their indictments did not allege in the charges that they committed obstructive acts related to, quote, a document, a record, or other object, they dismissed the counts, okay? So this big bucket of categories, this is a very important technical thing that's happening here. And the lower level court dismissed a bunch of charges. Dismissed. The government filed a motion, meaning the prosecutors were upset about this, and the district court denied. So the government appealed. How dare you not dismiss our case? How dare you? And so it's very technical, but this is how the law works. The law, you can't just say it's close enough, right? If they put in the indictment, as they did, meaning they charged these people in the indictment under 18 U.S. Code, they wrote out specifically the following things, and they're charging it under that statute. Now, if you read the statute, it talks about a record, a document, or other object. But what are the records? What are the documents? What are the other objects? Well, they're not really there. The government hasn't alleged them. This is the same problem we're running into the Trump case. In the Trump case, Alvin Bragg says he's got these mysterious crimes out there. And we're saying, okay, you might have them. They might be federal crimes, election crimes, New York state tax fraud crimes. There might be a million other crimes. But what are they? Because when this case gets processed through the criminal court, it's going to land in front of a jury. The jury is going to get jury instructions, and they're going to have to look through the law and match the things, check the boxes in order to convict somebody. This is how the system works. So the judge at the lower level court connects the two provisions, and he says, no, sorry, government. There is no document, there is no record, there is no other object, and so this statute can't stand. So he dismisses a whole bucket of these charges. And this is a bunch of charges. The government was using this a bunch because they couldn't find anything else. They talk about the standard of review, which basically means the court says, how do we weigh the facts? We'll fast forward. The analysis, they tell us now. The government responds. The lower level court, in a very rare victory, gives one point to the protesters, those of us who want a fair justice system. The judge says, yeah, this is an inappropriate charge. So the government responds. They assert, here's their argument. They say that corruptly and obstructs and influences and impedes has a broad meaning that encompasses all forms of obstructive conduct, including their violent efforts to stop Congress. The government says that a narrow reading of the statute is unduly narrow by saying that with respect to a document, record, or other object. They're saying the law says record, document, or other object. It's in there, but it's just too narrow. That's not what the law means. It says that, but that's not what it means. For their part, the court says that the appellees half-heartedly defend the trial court's interpretation, but more vigorously advance a different argument. That C2 prohibits obstructive acts related not to a record, a document, or other objects, but all evidence of general impairment. Do you see this? This is how this works. You think we're a nation of laws. That's not really true. I mean, we do have laws, it is true, but the laws can sort of mean whatever the judges and whatever the prosecutors want them to mean. The law, very specifically as written into the code, we just read it. I just shared it with you up here. You can see it. 18 U.S. Code. If you're charged under 1512 C2, these are the things they have to prove. And they have to go through this, a record, a document, or other object, or otherwise obstruct or influence, right? And the government is saying, yeah, I know it says this in the law. That's not what it means, though. It means other evidence generally. Prosecutors continue with their argument. They say that either under the district court's document-focused reading or their own theory, the defense is saying, no, it is a narrow reading and you have to dismiss because they're alleging conduct that doesn't fit under the law. They say that the court writes, well, here's what we decide. Faced with these three competing interpretations, guess who they decide with and side with? We conclude that the government has the best argument. You're kidding me. Weird. Court says we begin interpreting a statute by analyzing the language. They give us a breakdown. They say, let's reiterate and examine the text. Let's do it. Section 1512C, whoever corruptly alters, destroys, mutilates, conceals a record or other document with the intent to impair the object's integrity or availability or otherwise obstructs any proceeding. So they give us their interpretation. They say, well, in our view, The meaning of the statute is unambiguous, nothing to even think about. The statute has a prohibition against corruptly tampering with a record. Under most readings of the statute, this applies to all forms of corrupt obstruction. They go to the Oxford English Dictionary. They go to Black's Law Dictionary. They talk about the word otherwise. They say the natural, broad reading of the statute is consistent with prior interpretations of the words. The terms obstruct and influence and impede can be found in other statutes, and the word otherwise has been given a common meaning in a different manner. So the latter subsection, they write, is a catch-all that covers otherwise obstructive behavior that might not otherwise constitute a more specific offense. So the second part of it captures everything that the first part of it misses. If it's not a specific document, record, or anything else, the second part of the statute can capture everything else, and the government gets exactly what they want. They give us some precedent. They say other courts have given it broad readings, so it applies. Our peer circuits have also given it a broad reading. They say to defend a narrower reading, like the lower court judge held, involve evidence impairment, and the other precedent they say is just not applicable here. They say, just to be sure though, outside of the J6 cases brought in this jurisdiction, there's no precedent for using this to prosecute the type of conduct at issue in this case. Do you see that? They're telling us that. To be sure, outside of J6 cases brought in this court, there is no precedent for using this law, 1512C2, to prosecute the type of conduct at issue in this case. There's no basis. The judge is finding a basis for it, but they haven't had a basis for it up until January 6th, and they just concocted and manipulated the statute in order to use it in J6 prosecutions. And they give us some other case law. They say, but still, it is a generally phrased residual clause. It's a catch-all for matters not specifically contemplated. So they can use it for whatever they want. They say, although the statute plainly extends to a wide range of conduct, it does contain some important limitations, like it does have to be obstruction or influencing or impeding. It can't be beyond that, and it must have corrupt intent. And it must be an official proceeding. So these are their elements, right? Those same boxes that we talk about checking. They're telling us, no, these are the elements. It doesn't actually have to be a record or any of those other things. It can be any one of these things. And they fill them out for us. So obstructing, influencing, or impeding, does it check that? Maybe. Does it have corrupt intent? Maybe. Is it an official proceeding? Maybe. But the documents and the records and the other things that the law says specifically, we don't need this one. It's not appropriate because the catch-all fills that element. They just deleted the element out of the analysis. Those other elements are not the focus of the appeal, but we provide guardrails because there's going to be more prosecutions. So they talk about what corrupt intent means. They say that they declined to interpret corrupt intent, but it's relevant here because it does meet the element. It does meet the checkbox. They fly forward through that with some analysis. We see there's another argument about corruptly. Here is the definition of what an official proceeding is. So as we said, they gave us all the checkboxes, and now they're explaining the checkboxes. They're going to say here, right, this was corruptly because they did insurrect America. And here, it was an official proceeding because it was J6. They tell us that any other alternative interpretations are not appropriate, and they are basically dismissing the rest of the arguments. Now, we're going to fast forward through to the dissent because I want to see what the dissent says as well. They're going to give us a lot of historical context And if you really want to expand the analysis on this, you certainly can. But they're going to tell us where the act came from, where Section 15.2 came from Sarbanes-Oxley, having to do with Enron. They're also going to talk about, they're beefing up their argument, right? We've got a lot of historical precedent to support this, but it's all not that interesting. So we'll fast forward through it until we get to the dissent. We know what the main arguments are. They decided that certain sets of elements apply, others do not. So they say when no choice but is to make a ruling, they find that after consulting our laws, as we have explained, the law is clear, it's unambiguous, and therefore we have no lenity, we have no room for asking about alternative explanations in our analysis. So in other words, it's reversed. All of those charges are good. The government can charge essentially anything they want as long as it has those three elements, a much narrower reading of this. So the DC is happy, the DC courts are happy because more J6 prosecutions can go through here unabated. But there are judges who say, hold on a minute. If this is allowed, if this is permissible, it kind of means you can prosecute whatever the heck you want under this law because there's no limiting factor. There's nothing that stops you other than those elements. And those three elements are broad, right? They can basically be anything. So let's see what the dissent says. They write, before we get to the dissent, here is the final paragraph. For all the foregoing reasons, we conclude the district court erred in dismissing the counts of the charge. They dismissed all of these obstruction charges. So bring them all back. All of these obstruction charges are going to be coming back. Appellee's alleged conduct falls comfortably within corruptly obstructing an official proceeding. That's it. That's all they need. Any alternative interpretations proffered by the district court fail to convince us about this. Accordingly, we reverse the orders and remand for further proceedings. So a bunch of charges are coming back against the J6 cases. Now, the dissent is where I want to jump down to the dissent. Judge Katsas is upset that these charges got dismissed. Here's what he writes. This appeal turns on how the two subsections of 1512 interact with one another. Now, the first section addresses the preservation of physical evidence. That's why it talks about documents. And it imposes criminal penalties on anyone who alters, destroys, mutilates, or conceals a record, with the intent to impair the integrity of that document for an official proceeding. Now, the second subsection offers broader and less precise terms, imposing the same penalty on anyone who, acting corruptly, otherwise obstructs, influences, or impedes any official proceeding. So the question presented, says the dissenter, is whether the second subsection applies to obstruction that bears no relationship to the specific acts of spoliation covered by the first subsection. So do you see what he's saying here? He's saying that if we have these two checkboxes, they have to relate to one another. That one has to relate to that one. They can't be totally independent of one another, and you just can't pick subsection C2 out of subsection C1. C1 has to come before C2. The government reads section 1512 as reaching all acts that corruptly obstruct or influence an official proceeding. Very big, broad reading. In its view, the catch-all otherwise, that word, that alone determines the scope of the provision, and preceding examples do nothing to narrow it. So if you take that further, if a person corruptly obstructs an official proceeding, the first subsection applies. And if a person corruptly obstructs a proceeding in any other way, then the second subsection applies. So you've got to have a corrupt, altering, destroying of a record, document, or other object first before the second one triggers. You don't just jump over subsection 1. Subsection 15C thus reduces to a single provision criminalizing any act that corruptly obstructs an official proceeding. The judge says, in my view, The government's interpretation is mistaken. For one thing, it dubiously reads otherwise to mean in a manner different from or a manner similar to, which is not what it says. For another, it reads the catch-all provision in C2 to render ineffective the longer, more grammatically complex list of examples in C1, saying that C1 tells us what is appropriate. It says document, record, all of the things. C2 doesn't. And so C2 is being usurped because it's supposed to be read subsequent to C1. You can't just jump over C1 to get to C2. The government's reading is also, he says, hard to reconcile with the structure and the history of the law. Decades of precedent applying the law to other types of cases. And moreover, the government's reading makes the law implausibly broad and unconstitutional in a significant number of its applications. If you rewrite the law that way, then it causes all sorts of problems. And if that were not enough, this judge says, these various considerations make the question presented at least enough to trigger the rule of lenity. Now, because my colleagues rejected an evidence-focused interpretation of the rule and instead adopt the government's all-encompassing reading, whatever they want, they can prosecute, I respectfully dissent. He tells us that the three defendants, they allegedly participated in a riot on J6, including with assaulting officers. Now, this conduct would violate many criminal statutes. Among other statutes, they were charged with a bunch of them, including assaulting federal officers, causing civil disorder, entering a restricted building, and demonstrating inside the Capitol. But the government also charged them with something else, 15C2. It argued that the law comprehensively prohibits the obstruction of official proceedings, regardless of whether the obstruction has any connection to the spoliation of evidence. Meaning, was evidence spoiled? Was it destroyed? If it was, then that is what the law is meant to cover. The law is not meant to cover just interferences with official proceedings. The law says specifically it's about evidence, right? That's why it was written, to stop the destruction of the evidence. It's narrow, you can't broaden it out. On this account, because the defendants wrongfully obstructed the proceeding, they say they violated the provision. But there were no documents that they could point to that they destroyed. So the lower level court ultimately dismissed those counts. Said no, there's no basis for that, saying that C2 could be read as either prohibiting any act that obstructs an official proceeding or only obstructive acts similar to the one covered by subsection C1. So he said you could make both arguments and therefore it's ambiguous. The court concluded that a narrower reading was appropriate, as does the rule of lenity, saying that if you can't tell, if you can't decide what these things are, then you've got to default to a more favorable ruling for the defense here, right? A narrower version of this. We're going to read it more narrowly rather than more broadly. Now, the government appealed. They didn't like that. And they say we have jurisdiction to deal with this. And so the operative question is about this section. What are the elements? The judge gives us here, the dissenter, his elements. Now, he's got 4 of them. The first are the actus rei verbs. Just like we talked about the mental state and the actions that need to accompany a criminal charge. You have to think I'm going to do the bad thing and then do the bad thing. They can show you thought about it or that you did something that shows you thought about it. It was intentional. It was reckless. And you did the thing, and you've got a guilty mind and a guilty act. So he tells us we have a bunch of acts: obstruction, influence, impeding. The other is an adverb otherwise, which qualifies the verbs by indicating the relationship between the covered obstruction acts. And the third is the direct object. Oh gosh, it's a grammar lesson. Oh no. The defendant must obstruct an official proceeding. And the fourth is the mens rea. This is the guilty mind. What is the corrupt mind? So the question involves an act. What counts as obstruction? The literal meaning of the word is unargued. So they don't fight much about this. Instead, they default to the word otherwise. The judge says, in my analysis, I will first show that the word introduces ambiguity as to how these sections relate to one another, and then when there's ambiguity, it's best resolved in favor of the defendants because they're the ones who go to jail. He says there's a lot of overlap here, but unambiguous is what the standard is, and this is ambiguous, and that means it cannot stand. He gives us some more heavy law. You can see all of these are excerpts. We get more excerpts from Black's Law Dictionary. He gives us some very logical things that we're going to fast forward through. This judge is very technical. Holy moly. He's talking about A, B, C, and D is going to expand the meaning, and it's getting very technical here. He says, not surprisingly, these linguistic points coincide with several semantic canons of construction. We'll fast forward through all this. All right, this judge is out of control, man. All right, so let's see where he says, oh my gosh, this is like, this is out of control. It's like a logic game. This is amazing. All right, we're going to fast forward through this. We want to see where he's getting to the other elements. Now, how do these general principles apply? Great. Finally, we're here at section D. Finally, he said, and I love it. I love it that he's doing that. I mean, these judges, man, they will take one word. What you saw was multiple pages about basically one or two words, the word otherwise. And he analyzed it. Do you see all these these are all logic games and sort of, logic words. And he's putting together all of these, changing everything around. It's just a lot. So we'll fast forward through it. So he tells us in summation. Now, how does this all apply? He says, without the line break, the act covers anyone who destroys, mutilates, or conceals a record with the intent to impair the availability for use in a proceeding or otherwise influences the proceeding. So he writes, these two subsections don't even fit neatly together. And so what this is showing to me is that it is very awkward. It is very ambiguous. And he's explaining all the ambiguities. These sections don't fit neatly together, but the defendants win in their interpretation because the indictments do not allege that they took any action affecting physical or other evidence relevant to the certification. That's the key point in this whole thing. He's saying you need more narrow reading of this statute. If you're going to be alleging that they did something illegal under 15C2, it's got to relate to a physical or something, other evidence. It doesn't have to be a physical document, but something relating to certification. Just being there is not enough. The statute is there to protect evidence from being spoiled. And they're charging this under a catch-all phrase that's not about evidence being spoiled. So they're being charged with a crime that covers conduct that they didn't do, but they just read the law broader. They just turned the law into something that covers more conduct. They charged them with a crime. The DOJ says it fits. This judge says, no, it doesn't. Court said, yeah, it does. You read the law. You saw what it says. They're just reading it broadly. And for the reasons given above, it seems to me a stretch, says this judge, to say that the government's interpretation is not only the best, but so much better than the others. They have not even done a full-blown statutory analysis, he says, like I have. And he definitely did, right? They didn't do that in the majority opinion. He says, my colleagues conclude that they didn't do any analysis and they just pick out whatever they think otherwise means. And he says this statute is ambiguous and therefore we cannot uphold it. And he's still going, just so we're clear on this. Still going on this. I think this is longer than the majority opinion. And let's see if we get to anything good here. This is good. He says the government's interpretation of the law injects significant anomaly into the code. It has a 20-year maximum penalty. This judge is extremely thorough. It's crazy. He's basically saying that this stands out of some of the other penalties. And the titles don't even match the other titles in the law. The government posits that Congress plugged the loophole, but it's still ambiguous. There's a mismatch here. he says, he's giving us some comparison cases to other cases. I'm seeing if he's going to be wrapping this up anytime soon. This guy is extremely thorough. Holy moly. Improper benefits test. Talking about the concurrence. He says, finally, my colleagues and their approach creates vagueness problems as well as First Amendment problems. He says, consider this. Anyone can have penalties applied, but in rejecting the government's argument that a mens rea requirement, a mental state, sufficiently narrowed the statute, corruptly can basically mean anything. To cure the vagueness, we limited the act, and the government's construction creates improbable breadth and a host of unconstitutional applications the way they interpret it. He says, if there were to be any remaining doubt, he says, I just gave you 25 pages of very technical analysis. But if you need anything else to convince you, we need to talk about obstruction of justice. We need caution. The Supreme Court has repeatedly urged caution in this area. And the conduct here violates many criminal statutes, but Section 15C is not among them. Because my colleagues conclude otherwise, I respectfully dissent. Now here's the appendix. Here's the actual law that they're referencing. And you see it here. So the summation of all of this is it's a dispute over one section of the law, this one right here, and how you read it. Now, if you take a quick look at it one more time, having read all of that, they say whoever corruptly, so we're arguing over this element, which is a mental state, alters, destroys, conceals a record, document, or object to destroy it or impair its availability for use in an official proceeding, or otherwise obstructs or impedes any official proceeding, or attempts to do so, shall be fined not more than 20 years. So it depends how you read it. The government says this is a catch-all, or otherwise obstructs means anything else, maybe because of the or this is a subsequent reading, which is just modifying the underlying first part of the statute. So the majority court finds that this is a broad reading, and so the charges will come back, which means a bunch of additional charges will be showing up for many J6ers as courts reopen on Monday. So a bad opinion that came out, one I vehemently disagree with. I can't stand it when they overly expand the definitions of statutes to encompass whatever they want. Now, of course, we'll see what the defense does on this, whether they appeal this up to the Supreme Court, whether the Supreme Court wants to weigh in on this. But we've seen a pattern here where the DOJ and the prosecutors, they are doing everything they can to prosecute the J6ers. We're seeing evidence uncovered or covered up, not uncovered, made available to the defense. The Proud Boys trial is still moving on. They were out of court today, and they'll be back in session next week. But of course, we will continue to cover this and more, and we hope you join us as we do. Thank you for liking this video. Thank you for subscribing, and forward to seeing you on the next one.